El señor quiere saber si un estudiante que va a tener el beneficio de la acción diferida va a quedar como in-state o no, si va a tener que pagar como estudiante extranjero o estudiante del Estado. Esa es la pregunta.
Todavía tienen que pagar como un estudiante fuera del Estado. O sea, eso es lo que han decidido, todavía no ha habido otro cambio. Los colegios están tratando de ver cómo esta ley va a afectarlos, todavía no tienen la información. Entonces van a seguir con el mismo plan que han tenido. O sea, que van a dejar a los estudiantes que son documentados asistir a la escuela, pero tienen que pagar como si fueran estudiantes extranjeros.
Pero ya no sería ni documentado.
Pero esto es simplemente un trabajo, es un permiso de trabajo. No tiene nada que ver con el permiso de ir a la universidad y aplicar como estudiante estatal. Pero es buena pregunta lo que usted preguntó.
Por ejemplo, mi hijo está estudiando en Indiana en un colegio privado. Yo insisto a todos de que hagan un sacrificio. Estoy pagando alrededor de $2,000 mensuales. Es indocumentado, pero sé que va a haber algo para él porque está aquí desde bebé. 20 años tiene ahora. ¿Dónde él puede aplicar? Él me pregunta, aquí en North Carolina, porque aquí dice que su residencia, solamente va a estudiar y regresa.
Did you get it? The student is in Indiana, but the address is here. Where is the place that he needs to apply? He's attending a private school in Indiana.
And again, a lot of these questions still aren't clear. We don't know, for example, whether all of these cases are going to be reviewed at a central address where people mail them in, or whether they're going to be reviewed in the local offices. You haven't decided that yet, right? Okay. So I don't think it really matters, really. What I tell my clients is that the best place to apply is the place you have all your information and documentation. So, but it shouldn't really matter if they apply in Indiana or California or North Carolina, because the same rules should apply across the board.
Mi pregunta es referente a los muchachos que ahorita ya, por ejemplo, puedan ingresar al community college o a un colegio. Una vez que ellos acaben su carrera, ya sea 2 años o 4 años, según lo que hayan ellos decidido, bajo esta ley que quedan amparados o protegidos por 2 años con su permiso de trabajo, ¿algún empleador les puede dar el beneficio de la residencia o un permiso de trabajo ya más, una vez que tengan ya una carrera, ya sea técnica o universitaria, pueden ya por medio del empleador extender su beneficio?
So, deferred action is completely apart from any application that a family member or an employer would file on behalf of a beneficiary. One aspect of the law is that while you have deferred action, you're not accruing unlawful presence. This is a complicated thing to explain that I'm not going to try to right now, but in the future, if the person with deferred action has a job offer, or a family member can apply for them, that's the time to speak to an expert who can explain that person's rights and opportunities.
So today's meeting about the unauthorized practice of immigration law and deferred action for childhood arrivals is an informational discussion. Members of the media who wish to attribute information or who have follow-up questions are asked to call Sharon Scheidhauer, the Public Affairs Officer with the U.S. Citizenship and Immigration Services Media Team, and her number is 202-215-1227. So as many as you know, on June 15th, the Secretary of Homeland Security, Janet Napolitano, announced that certain young people who were brought to the United States as young children may be considered for exercise of prosecutorial discretion. When you hear prosecutorial discretion, you will be hearing it now as deferred action for young arrivals or childhood arrivals. So that'll be the term when you hear USCIS talk about it through our website, through our 1-800 number, and our offices as well. So what is USCIS's role in regards to deferred action? The Secretary's memorandum gave USCIS 60 days from June 15th to create a process to accept deferred action requests. USCIS will provide additional guidance on how this process will be implemented. Please do not request deferred action based upon the Secretary's announcement until USCIS issues further guidance. Any requests that you may submit now will be rejected. Once a new process is in place, individuals who are not currently in removal proceedings or who are subject to a final order of removal will need to submit a request for review of their case and supporting evidence to USCIS. Individuals may request deferred action if they meet the threshold criteria for consideration. Deferred action does not give lawful status upon an individual. It does not forgive individuals of any previous or future periods of unlawful presence. The Department of Homeland Security can terminate deferred action at any time within its discretion. By mid-August, USCIS will establish a process that will enable qualified individuals who came to the United States as children to request deferred action if they are either not currently in removal proceedings or have a final order. USCIS recognizes that immigrant communities will be highly susceptible to misinformation during the time while a process is being put in place. Therefore, we are engaging with the communities in our 26 districts between July 9th and July 31st to emphasize the agency's ongoing commitment to combating fraud, scams, abuse, and the unauthorized practice of immigration law. Today I did bring the pamphlets regarding that, and they're here. We want to make sure that you understand where to get the information once it's put on, once USCIS has announced the details. You are more than welcome to go to our website, which is www.uscis.gov. It's never .com or .org. Sometimes there's websites that look exactly like us, but they're not. And you may pay for a service on that site, but you're not paying for a service with USCIS. We never charge for forms. You can always get a form free from our offices or through our website. If you have questions additionally regarding deferred action, and after the program details are released, you can always call our 1-800 number, which is 1-800-375-5283. And you can be assured that after the program details are announced, that we will be going out to the community, as we are doing today, and we'll bring you full details of the program. We'll do presentations, workshops, to make sure we can reach as many people as possible that can possibly benefit from this program. And finally, we want to make sure that you seek information about the new process from official sources like USCIS, or seek legal assistance and advice from only attorneys or Authorized legal service providers. I want to thank you again for this opportunity, and I'll turn it over.
¿Alguno tiene preguntas para Aitlin?
Yo quería preguntarle, tengo una hija que tiene síndrome de Down y que cubre todos los requisitos, ¿ella también podría aplicar? Tiene ya 21 años. Está yendo al colegio también.
Once the program details are announced, if she meets the criteria that's listed already by the secretary and any additional developments that come out after August 15th, then if she is eligible, she could apply as long as she's older than 15 and meets all the eligibility requirements that are set forth.
Bueno,
Si todos aplicamos, ya todos los estudiantes y todo, a los que no están en el proceso de deportación y los que ya están en el proceso de deportación, si cambian la ley años después, por ejemplo de aquí a 3 años, todos podríamos ser elegibles para estar en proceso de deportación, vaya, o sería dependiendo qué leyes vengan.
Okay, at this moment, I can only speak of what has been issued by USCIS, so we know that this program will be good for 2 years. I can't speak in the future, and we would really have to wait until after August 15th to see what the details are of the program before you can make a decision. I could not give you that information at the moment, so I would really suggest that we wait for the details to come out.
I want to ask a question that many people have asked me. I think your answer is going to be, I don't know, but I want you to hear this is something that everyone's very concerned about. If the mother or father of the person who submits the application has a prior deportation or removal order and is now in the United States, this person falls under what Immigration and Customs Enforcement calls a fugitive. And Immigration and Customs Enforcement has made it very clear that they're looking for fugitives. Is there the possibility that this information could be used to then go after the parent?
Well, I welcome that you asked that question, and actually I should have made an announcement prior to. In us going out to the community and speaking to everyone regarding deferred action, we also wanted to hear your concerns about this program. As the individuals, our leadership and headquarters are working through to finalize the program details, they wanted us to get the concerns of the community and then forward that to them. So I will be forwarding your question to them, definitely, because they did want to hear that. Director Mayorkas had a town hall meeting with the port director, CBP, and then ICE as well. They had that question, and again, he did answer it, so I shall not answer different than him. But I think we want to wait till the program details come out. But if you would like to give me any concerns or comments about the program, I would appreciate it, because I will take them up to leadership and let them know what our community here in Raleigh has to say about the program and what the potential effect it could have on your families as well.
una pregunta más y ya pasamos con María Rosa Rangel.
Will tattoos disqualify you? Yeah, will tattoos disqualify you?
Tattoos. No. No. Ok, María Rosa, empezamos ahora contigo.
Sí, no.